So here tonight, we are going to finish our chapter 3, which is a little bit more on the, we're going to do easements, and we're going to talk about encroachments. So we're talking about encumbrances on property. But we have a busy night tonight because now after we finish those, we're going to start talking about real estate taxes. We're going to introduce you to the math packet a little bit. We're going to do some math. Then after that, we're going to get into the, measurements and how we, not measurements so much as measuring a house, but how we put an exact name and article to find your property. Your street address is just a placeholder. So we're going to talk about, what do we need? We need a lot, we need a block, we need a section number. What kind of detail do we need so that a surveyor can find your property? So we'll talk about that in chapter 4, and we'll go as far as chapter 4 as we can. And time permitting, we'll have a little bit of I don't know if we'll have time or not, but if we're going to try, I'm not going to rush because I want to make sure that you get the math that we're going to do as we go through it. But I have some quiz questions at the end of the class just to make sure that you are where you need to be. All right, so we're going to add a few quiz questions. If not, I will give you the quiz questions and then you can do them over the weekend. All right, we want to make sure that everybody's on the same game. We are all on the same page. So we have a few things to cover. All right, so everybody have a calculator? Gonna need a calculator. Scrap paper, gonna need some scrap paper. Pencil, pen, all right, something that you need to do. So when we get there in a very few minutes, we're going to start talking about real estate taxes and how they're handled. And the math part is simply a matter of reading the questions. That's not a big deal. The math, but it is handled a little differently here in the fact that we are there's three different ways to handle it, depending on the date, depending on the month of the year. So we'll get there and we'll talk in detail about how we figure that out. So, and we start talking about, is everybody comfortable with debits and credits? What did he say? What's a debit? Debits and credits, right? If you are paying a bill, you are being debited. If you're collecting, you're getting a credit, right? So debit is debt, collecting is a credit. Remember that, keep that in the back of your head. We'll talk about that in detail as we get down the road, because you're going to need to know exactly how that works. All right, that's just one of those things. If you go to the website, if you go to the Seacoast website, they have that additional materials area there. And in there, you can find the link to the Learn Test Pass. And I believe they give you a free 90-day membership, which is really all you need, right? At this point, January, February, that's 60 days. That's enough. Okay, so yeah, that might be the place you want to go. Okay, this is on page 47 in your book. 47 in your book. I don't know why it does that now. I don't like that, but. Okay. So question number 1 in unit 2. Real property is often referred to as the bundle of legal rights. Which of the following is not among these rights? Okay, first of all, you never have the right to override local zoning without their permission. That would be a variance, which we'll talk about as we get into chapter 6. So that is not one of your bundle of rights. You don't have the legal right to do that. You can do what? You can, it's deep C, right? Dispose, exclude, enjoy, right? You can, the P, you can possess, and you can control it, C. That is what you can do. So B is the right answer here. You cannot override local zoning. Matter of fact, if there's a dispute between your private restrictions and your public restrictions being the local zoning, the tougher of the two is the one that will be enforced at all times, whichever one is more restrictive. All right? So just keep that in the back of your head. All right, number 2. A property is bordered by a small stream. The property line ends where? If it's not navigable, we can't float a barge down there or any kind of commercial vehicle. it ends at the center of the stream. It ends at the center of the stream. If we can float some sort of commercial vehicle through there, jet ski, boat, anything else like that, our property ends at the water's edge, okay? At the water edge. So small stream, property ends at the center of the stream, okay? Number 3, oceanfront property ends at the mean high water mark. The mean high water mark. Tide comes in, tide goes out. Now this is for lakes and oceans. It's called littoral rights, L-I-T-T-O-R-A-L, littoral rights. And it ends, my property ends at the average high water mark, okay? Now what happens, who owns that property when the water recedes? When the water recedes, that becomes property of the public. In North Carolina, that is public property. It's called, the word is foreshore, F-O-R-E-S-H-O-R-E, okay? And that's the difference between where the water is and the average high water mark. And that's why you can have public beaches, okay? That's why you can have public beaches, is from the high water mark to where the water is, that's all beach. It belongs to the government and the people, okay? Foreshore, F-O-R-E-S-H-O-R-E. Mm-hmm. Number 4, a property owner has placed a manufactured home on his lakefront lot. In order in order to make the home a legal part of the real estate, he must do all of the following except, now he must take off that trailer hitch, got to take off the wheels, got to take off the axles. Yes, he has to. It has to be attached to a permanent foundation which he owns, not leases, which he owns. Okay, can't lease the land, he has to own it. All right. And he's got to go to motor vehicle and cancel the title. Cancel the title on the vehicle. What he may not do, there is a sticker on the exterior of that manufactured home that comes from the Department of Housing and Urban Development, HUD. That shows that house is inhabitable and built to specifications that says that folks can live there. All right, it's built to that specification. So you cannot remove that label, that HUD label. All right, all those other things you can. All those other things you can. That's important to remember. Number 5. Which of the following would typically be considered a fixture? And it's a custom-made mailbox attached to the house, right? By method of attachment. Boom, we screwed it into the house. It's going to stay there. It's custom-made for the house, right? Don't forget IRMA, right? IRMA, right? Intent, relationship, method of attachment, and adaptation to the real estate, okay? In this particular case, it is meant to stay, right? Particularly by method of attachment. Number 6. Which of the following would not be considered in determining if an item is a fixture? If an item is a fixture, I just told you what they were. Value was not one of those, was it? Value is not one of those. Intent, adaptability, method of attachment, relationship to the annexer. All right, those all are. Value has nothing to do with the fixture. Number 7. Which of the following items would normally convey as a fixture with the property? All right. Which of the following items would normally convey as a fixture with the property? The D, the large mirror bolted over the fireplace mantle. Bolted, right? Built to last, stay there. Refrigerator, unplugged, unbuilt-in microwave goes, but freestanding butcher block, decorative lights draped around the patio. They all personal property. They're all personal property. Number 8. A seller spent $5,000 to have custom-made awnings installed over the backyard patio. According to the NCBA NCAR 2T offer to purchase and contract. All right, let's shorten that up a little bit. North Carolina Bar Association is NCBA. North Carolina Association of Realtors is NCAR. It is Form 2T in our lengthy line of forms offer to purchase and contract. This is the contract. This is the offer. Okay. So we might just say from now on the offer to purchase or the contract, it's all the same thing. It is the NCBA/NCAR 2T offer to purchase and contract. If I said that every time we talked about the offer to purchase or the contract, we would waste half the class just going through the title of that stupid thing. So we're not going to do that. All right. We're going to stay away from that. All right. So it is the offer to purchase, but just understand NCBA is North Carolina Bar Association. NCAR is North Carolina Association of Realtors. Right? All right. So a seller spent $5,000 to have custom-made awnings installed over her backyard patio. According to the contract, what's the status of the awnings? If they are custom-made and they're built in, awnings are considered real property and have to stay. They're a fixture. They're a fixture. They're custom-made for that particular property. Number 9, a purchaser of real estate learns that her ownership rights will continue forever and that no other person has any ownership control over the property. This person owns a fee simple interest, right? That's the best type of ownership you can get. Fee simple means it's inherited, all right? And there are no conditions in this particular case. Okay. Number 10. A fee simple estate has all of the following characteristics except that it is. All right. So it is, that means it could be encumbered. We're going through the encumbrances now, right? It could have liens on it. It could have easements on it. It could have encroachments on it. So there's no guarantee that it doesn't. We have to get those cleared up or understand that we're going to have to live with them. All right. But a fee simple estate, indefinite duration, I can hold it forever. All right. Transferable by deed or by will. I can will it to my kids. That's what the word fee stands for. All right. And it's transferable with or without valuable consideration. I can give it to it as a gift if I wanted to. I can just leave it right through in my will. I can sell it, any of those things. All right. Number 11, a freehold estate in land that will automatically extinguish upon the cessation of a specified condition is called a what? This is a fee simple determinable, right? I'm going to give you this land or I'm going to sell you this land with the rule that says that you must continue to use it as, if it's a hospital land, you must continue to use this as hospital property, doing whatever it is you're doing now, forever. If not, I can go to court and get it back. This is called a fee simple determinable, right? You're doing something, it must continue to be done, all right? If it's something subsequent, it would be condition subsequent, and we'll talk about that when we get to that question. Number 12. A property owner wants to donate to the hospital a vacant lot she owned adjacent to the hospital for expansion purposes. This is pretty much my explanation of the last question. She wanted to make sure the land was used as she intended. So her attorney prepared the deed to convey ownership of the lot to the hospital, so long as it is used for hospital purposes. Upon receipt of the gift, the hospital owned a fee simple determinable estate, right? They got to keep using it the same way she said, and they can keep it. If not, she can go to court and get it back. Number 13. A property owner has a freehold estate in a single family home. He rents the home to a young couple. Which of the following statements is true? All right. The owner has a freehold estate in that property. He owns it. And the tenants have what's called a leasehold estate in that property. Freehold, and then the tenants would have a non-freehold estate or a leasehold estate. Okay. So they have it. That's your estate is your position in real property, right? So if I own it and I rent it, I have a freehold estate, I own it. They have a leasehold estate or non-freehold estate, they rent it. Number 14, An example of a condominium limited common element would be a storage locker. A limited common element would be anything that only you can use, yet you don't have ownership over. You have an undivided part of it, right? It came with your HOA dues, basically a storage shed. You don't have a, everybody can use the pool, right? Not everybody can use your storage locker, only you can use it. Everybody can use the tennis court, only you can use the storage locker, all right? Same thing with the clubhouse. So that is a limited common element. If property, number 15, if property is held by 2 or more owners as tenants in common, the interest of the deceased co-owner will pass to the heirs of the deceased owner. Heirs of the deceased owner. You can transfer property by, if you are owners in severalty, right? A single person owns it, they can leave it to their heirs. You can transfer it by will. In tenants in common, you can transfer your share. You may not transfer by will under joint tenants with rights of survivorship or tenancy by the entirety. Both have the rights of survivorship. They cannot be defeated by a will. Okay, joint tenants with rights of survivorship and tenancy by the entirety. They cannot be defeated by a will. They go to the other parties. Okay. Number 16, what form of concurrent ownership can only be held by spouses? And this is tenants by the entirety. And keep in mind, this is the favored position for spouses in North Carolina. That is where they want you to go, all right? When you go and get your purchase, when you go purchase, they want you, if you are a spouse, husband and wife, taking possession, buying a house, they want you to use tenancy by the entirety. If you don't ask for something else, that's what you're going to get. Okay. William, Frank, and Jane, number 17. William, Frank, and Jane are tenants in common. Jane sells her interest to Lloyd, and then Frank dies. As a result, William, Lloyd, and Frank's heirs are tenants in common, right? Because as tenants in common, they don't share in ownership. Each one has their own individual section, right? Everybody owns 33%. Nobody has any survivorship rights, right? And tenants in common. So Frank's heirs, he left it with his kids. They own his share. Lloyd owns Jane's share. She sold it to him. And William still owns his share. All of those are correct. Number 18, concerning concurrent ownership. Which of the following statements is or are true? Number 1, tenancy in common is not available to a married couple holding title on a property. Tenancy in common is available to a married couple, right? You can ask for any of them. You can ask for any of them. So you can, even if you're going to be a married couple, you can go and say, we want to pass it to our own heirs. What if I was like Jack that we used the example of the other night, and I have 3 kids, and Jill says, yeah, he should leave it with his 3 kids, right? I can certainly ask for tenancy in common. Sure can. So that wouldn't be our answer. So number 2, joint tenants may hold title to the property with equal undivided interest. That's true. That's true. When you're a joint tenant, one of the possessions is you want to be equal interests. Okay. So number 2 is correct. That is true. The other one is not. Would survivorship override Tyler in which case? I'm a little, in this particular case, what happens is if I had, anytime we have survivorship, it will override any kind of tenancy in common or any kind of will, period. If it says survivorship in that ownership, which would be the 2, tenancy by the entirety or joint tenancy with rights of survivorship. Okay, either one, right? That they both have survivorship. You can write all the wills you want. You will never give it to that person unless it's the surviving spouse or the other parties who are owners, surviving owners. Okay, so ownership in severalty and tenants in common, you can leave to your heirs via will. The other ones you may not. Number 19. A buyer and a seller developer executed a purchase contract for a new condominium on May 6th, with the buyer giving $5,000 in earnest money. The buyer changed their mind and notified the seller on May 11th that she was rescinding the contract. Which of the following is true? Now remember, how long do we have to get on a new condominium project, right? How long do we have? What kind of right of rescission? We have 7 days, right? 7 days on new condos, none on resales, 5 days on timeshares, right? And then none on townhomes. So the buyer can legally cancel the contract and have all the earnest money refunded. Got 7 days, right? Got 7 days on new condominiums. Number 20. Which of the following statements is or are true? Number 1, a condominium owner individually owns their only the airspace in the unit and no land. You all know what condo ownership is, right? We don't own land. Only in townhomes we do, but not in condos. We own airspace, right? And number 2, a townhouse owner individually owns the ground under their unit. Both are true. Both are true. If you have a townhouse, you own the land underneath your unit. If you're in a condo, you just own the airspace inside your unit. All right? And that's the difference between the two. It's a pretty big difference. The difference in pricing. Same thing in measurements if we're doing it. Okay, number 21. According to the North Carolina Timeshare Act, a certificate of registration for each timeshare project must, number 1, be obtained from the North Carolina Real Estate Commission. That's true. And 2, be renewed every June. That's true also. And this is the reason why North Carolina, the Real Estate Commission, can fine these timeshare developers, because they don't do this registration and they need to do it every year. And it is $500 fine per violation. So you can figure out how much that could cost if they don't do it at all, right? Gets a little bit expensive. So they have to find that, put that registration together, certificate of registration, who bought it, who sold it, all of those things. All right. Number 22. According to the North Carolina Timeshare Act, all of the following are true except B. A timeshare person must provide a public offering statement about the timeshare project to a potential buyer prior to showing or sharing project information. No, that's not true. All right. What it is that it is prior to what? Getting into a contract, prior to closing, right? Before contract. So you can show the properties, you can share project information, you just may not sell it, get under contract. Okay. So yeah, there it is right there. Watch those one worders, right? It is, can't get into contract with it. Number 23. Each timeshare developer must deposit all money received from a purchaser in an escrow account for 10 days. Remember your rules of 5, right? And timeshare is any time, but we have 5 periods over 5 years, right? That's considered a timeshare. We have a 5-day right of rescission, and they have to put their money in an escrow account for 10 days, 2 5s. All right, that's for timeshares. Number 24. A prospective client wishes to list his property with a broker and state that the property is held in a trust. Which party should the real estate broker contact in order to proceed with listing and marketing the property? Okay. Keep this in mind, and I know that this becomes a question. I've seen this in virtually every exam that's out there, okay? You do not negotiate with the beneficiary. You negotiate the trustee. The trust is the true owner. So your negotiations and your purchase and everything else is through the trust, not who they're working for, not Oprah, not Tiger Woods, not any of those people. The trust, Dewey, Cheatham and Howe, that's our trust, right? They are the ones who we purchase through. All right, so keep that in the back of your head. You might hear that again. Okay, keep that in the back of your head. All right, last one. One advantage of a trust is the assets of the trust may be able to pass outside of probate. And I think I explained that, right? God forbid something happens to one of the beneficiaries. Well, the state doesn't have to take a look at all the assets before it passes to the rest. Because who owns it? The trust owns it, right? Those people don't own it. Those people don't own it. Technically, dotted line, they're the beneficiary for everything that happens, but they're not owners. They're not owners, okay? So we pass this outside of probate. What's the difference between a trustee and a fiduciary? Not much, honestly, not much. A fiduciary is in a position of trust and confidence. Somebody's trusting you to do something. You're going to be a fiduciary when we start talking about agency in Chapter 7. You're going to be considered a fiduciary for the simple reason that people are going to tell you information that they wouldn't share inside their family. How many of you married folk out there, or anybody else, has gone to your significant other's mother and told them how much you got in the bank? I would say probably not many of you, if any of you. But yet, what's one of the first things that you're going to do as a real estate broker when they come in and say, I want to buy a house? What are you going to ask them? How much you got in the bank? How much can you pay? You're going to start getting a lot of information that they wouldn't share with their family. Therefore, they have to trust you. So being a fiduciary is in a position of trust and confidence. Same thing with the trustee, right? They got to do the same thing. They work for somebody else. They represent somebody else doing that. So you're exactly the same thing, only we're not working in a, we're not purchasing for somebody else. They're going to sign on the dotted line. We can't bind our clients as a fiduciary. The trustee can bind their clients. Right? Because now who's going to pay? Who's really going to pay when Tiger buys through that Dewey Chudy Manal, the trusteeship? Tiger's going to pay, right? He's going to end up writing a check to them for X amount of thousands of dollars, right? He's going to pay for it. And the law firm or the trustees are going to sign for it. But for us, we're not going to bind our client. They're going to sign their own. But they have to be able to be comfortable with us, right? I mean, that's the key. That's the key. So if any of you have already told your mother-in-law how much money you got in the bank and how much you're looking to spend, that's probably not something you want to spread around, right? I'm willing to talk. I'm talking to nobody. I get it. All right. Everybody understand that? So yeah, but we will be fiduciaries, absolutely. And there are rules for the fiduciaries. We don't want to get ahead of ourselves. All right. Any questions on Chapter 2? Because I am moving on. That's a good review of Chapter 2 of those questions. Hit the spot there. Don't forget Chapter 2. A lot of little things in there. Same thing with there's some things in Chapter 3 that we're going to work on. All right. I'm going to go back to the when we just start talking about easements, because this is a really important thing that you need to get in your head. And when we talk about servient tenements and dominant tenements, so we're going to go through that. Let me make sure everybody has the PowerPoints for at least chapter, what do we got? We got Chapter 3 and Chapter 4 we're going to do tonight. So let me put this back in here. We're going to give somebody the right to use our land, but we're not going to give them ownership in an easement, okay? So there are two different types of easements. One is an easement appurtenant. And what's the word appurtenant means? Runs with the land, okay? It's with the land. And the other one is an easement in gross, okay? Gross is a little bit different in the fact that there's no dominant tenement. We're just going to give utility companies, power companies, anybody who we said, allow them to come and fix things or do things. If we want cable TV or we want high fiber optics, we need to let somebody on the property to do that, right? So we give them an easement so that they can come and do just that. All right, now, easement appurtenant runs with the land and not with the owner. So when you sell it, okay? And it does last forever until we get it taken out. Now, these easements that are appurtenant must be recorded. And that's the key part there. If we don't record an easement, if we don't record this easement, can the next person come in and say, hey, look, stop using it? You can't do it? New owner can say no, yeah. As long as it's not a landlocked situation, and then the owner of the other property can go back to court and say, hey, I can't get to my property any other way, and I've been doing it for 20 years. At that point, they're going to make them record it, though. But if we buy a property with a recorded easement on it, we can't make it go away, all right? Unless we agree, you know, there are ways to do this. Again, I'm talking in absolutes by the letter of the law, but obviously anything two people can agree to get into, two people can agree to get out. And just remember that in the back of your head. Yes, we're giving you the rules, but anything two people can agree to, two people can agree to get out of, all right? As long as you put it in writing and you agree, that's fine, all right? You can do that, even with our contracts. So it's not iron bound on either party if one says all of a sudden, now that we don't want to do this. You can do it, all right? You can get out of it. All right. So the easement that runs over the property, my property, is a servient tenement. I serve, okay? I serve my property. There's a driveway. Gentleman who lives next to me has no way to get to his house unless he goes across the backyard or across that road by the lake and goes to his property, right? Otherwise, he can't get there. He doesn't have a helicopter. He's got to get there. And we are not allowed to landlock anybody. Just because I bought this property doesn't mean that I can shut him out of his house. So I am going to have to be the servient tenement. Now, what's he going to be? He's going to be what? A dominant tenement. He's going to use my land for his well-being, right? He's going to use somebody else's land. He didn't pay for it. He didn't pay for my land. He didn't pay for that roadway, but he's going to use it, and it's going to be recorded that until he finds another way out, he's going to have to use that land to get there, right? So he is a dominant tenement, dominant. They're using it, all right? Now, this is appurtenant. We talk about these easements of appurtenance that are recorded. It's appurtenant to both parties. The dominant, the new owner, if he sells it, the next person who buys it's going to need to use that. We can't just shut him out because he's a new owner. We're not allowed. Okay, not allowed. So remember, servient is the property owner who serves, who land is used by others. Dominant is the person who uses somebody else's land. Okay, and it is appurtenant to both tracts. It has to be recorded for it to be appurtenant. Right, has to be recorded. A recorded easement. Ah, there it is. An easement must be recorded to be binding against the purchaser of the servient estate. If they don't show, if I don't say anything, and we're just doing it as a handshake agreement, if I sell it, no good. It could go away. Then you start all over again with whatever headaches and heartaches that you had. Okay. Easement appurtenant. Now, an easement in gross, right? I have a road that's in the middle of my property. I want it paved. Well, I have to let what? The paving company come through my property, right? Use my property. I have street lights that I need to get repaired. I got to let the street light people come and fix the property. For any other reason that they come. Cable, I want cable TV. I got to let them come in and repair it, right? So I'm giving them what's called an easement in gross. I am still the servient tenement. Everybody's still using my property. But I don't have it. There's no dominant tenement. There's no other property who's involved here. It's just that these public utilities and things are using my property. Okay? They're using my property. I am the servient. I can let people come over, use it, do whatever. But there is no dominant. All right? So it's not usually assignable unless owned by a company. So they can't, the power company can't say to the gas company, well, you can go take our power, our easement and go use it. You just go on the land. No, that's not going to work. They're going to have to do it directly. They can't do that. All right. So it's not assignable. All right. Ultimately, it goes away if they take the power lines down or they don't redo the repave the roads, is what I meant to say. This terminates with the death of the easement owner or the dissolution of the company. So we don't have a long-term, it could be long-term, but if I die and we have a new owner, can the new owner come out and say, I don't want you on my property anymore? Sure, it's not recorded. It's not recorded in that case. Now, if you look at these two lots, this is lot A and this is lot B. So here's an easement in gross, right? We have power lines along lot B. They got to come fix this, right? We have roadways along lot B and then some in lot A. Well, when they come along and fix this, or somebody's using that road, are they not easements in gross? You can use the road, right? Maybe I own both sides. Maybe I'm a farmer. I have a big field over this side. I own both of it. But the lake is here, right? Maybe I let people come in and use the lake. Maybe it's a 5-acre lake, right? And I have it open to the public for now. It's not individual, but if they want to come use the lake, that might be an easement in gross, right? There's no dominant tenement. You know? Who's responsible for maintaining it? It depends on your agreement with the city, probably you. Now, this would be because of maintenance, but yeah, if somebody is going to use my lake to go fishing and whatnot, they're responsible for cleaning up after themselves, and I can revoke that easement in gross, right? I can terminate it. I would give it to somebody as a license, but if this was like a 10-acre lake in conjunction with the city would probably clean it, right? I would still be the property owner. So a lot of little things that go into that. So let's look at what we have here. If I have this roadway, if this is the public road, and my entrance, I own lot A over here, and I have to come over here to get down to this roadway, I'm on B's property, am I not? And then I got to come across because I have all these trees in front. So this is B's property. That is an easement he's given me. Okay, that's an easement he's given me so I can come over here. And same thing with when I come over, if I want to use A's lake, if I am property owner B, I'm going to cross the line. I have an easement, right? Easement appurtenant, I can go to the lake. Okay? And any kind of power companies, things of that nature that are crossing over to do work, that is an easement in gross. The only big deal there is that there is no dominant tenement. In this particular case, am I using his roadway? I am the dominant, he is the servient. And vice versa, if I'm going to the lake, I am the dominant and lot A is the servient because I'm using his property. Right? If it's recorded, no. If it's recorded, no, because that is a dominant tenement situation. That's not an easement in gross in this particular case. That's on my property. So if I'm an owner of lot A, if they've recorded this, and again, it's a situation on the lake. If we just say it's a lake, there's a lot more detail. Is it a public lake? Is it city maintained? I've made a deal with the city? You know, again, there's 500 things that go with that. All right. So in an absolute vacuum, it's hard to answer that question. But if let's say that I own the lake, and lot B has been using it for 10 years, I can stop him. No easement, nothing's been recorded, I can stop him. But if he's been using it for 20 years and I never stopped him, what can he say? What? An easement by prescription, right? He can do an easement by prescription because I've been using it for 20 years and nobody stopped me. No, and you're right. Lot B can't stop lot A's because necessity. He's got to get there, right? That's an easement by necessity. Yes, this would be an easement by prescription over time. This is an easement by necessity. All right, commercial easements in gross, long-term, a recorded easement does not terminate automatically, even if not used for long periods of time. The easement runs with the land. Again, we record them, they can use it. What if there's train tracks that run through the back of my property? Electric lines that run through, high tension wires that go through, right? Those are easements in gross. Those don't terminate. How often do you see somebody working on those electric lines? Probably every, few years. So it's not like they got to keep getting something like that. They last a long time, right? And they are recorded. So how do we create this thing? Right? How do we create this monster? We can write something up, and that's the best way to do it, right? Written agreement, grants, and we're going to record it with the Registrar of Deeds. And we're going to see a little bit about the Registrar of Deeds later. We can do it by implication. Guy's got a piece of property behind the tree line, and he's got no way to get there. He's going to need it, right? Necessity. Okay. And then by operation of law, which basically says, hey, you've been using that lake for 25 years. You can't stop them now, right? Over time, easement by necessity. Easement by prescription, sorry. So you can't landlock anybody with an easement by necessity, so they got to be able to use it. They become a dominant tenement. Easement by prescription, all right? Not adverse possession, that's different. Easement by prescription is somebody who's been using a piece of property for a little period of time. Nobody said anything. He can go in and say, hey, look, I want this. I want to be able to continue to use this, all right? And it has to be open, continuous, right? Exclusive, adverse, and notorious. You can't be hiding and sneaking, really, is that what it means, right? And you've had to know, everybody's had to know that they've been using it. You just never said anything.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.